الأسبوع اللي فات. This is a fact.
Good evening, ladies and gentlemen. It is my pleasure to inaugurate this session or this lecture organized jointly by CLAC and the Cairo Regional Center for International Commercial Arbitration and with the media support of the CIR Egypt. The subject of this lecture is dispute boards in the construction industry. We have a very distinguished lecturer, Professor Dr. Sherif El-Haggan, who will enlighten us on the effectiveness of dispute boards, the different types of dispute boards, and its regulation in the FIDIC contracts, its functions, and the applicable procedural rules. The subject of this lecture is indeed a very important one, and the rise in the use of dispute boards in the construction industry has led the Corsica to issue for the first time in its entire history new dispute board rules, which have entered into force starting from August 2021. And Corsica believed that there is a very important, it is of a great importance to host notable speakers to enlighten us about this subject, and especially to start this series of lectures about dispute boards with a very prominent speaker who is the pride of Egypt and the Arab world and the African continent, Professor Dr. Sherif El-Haggan, who merits an entire lecture in order to benefit from the rich content of his knowledge in the field. Dr. Sherif El-Haggan needs no introduction, but I will briefly mention that he has over 40 years of experience in the field of arbitration, mediation, adjudication, contract administration, and claims consultancy. He is the partner and director and owner of CAB, which is the Contract Administration and Arbitration Bureau. Dr. Sherif designed also the construction law program known as CLAC, which is a landmark program that in which you know that in which the FIDIC contract, the different types of FIDIC contract and construction contracts are taught, in addition to the claims and arbitration law and evidence law and the law of obligations. The CLAC was hosted in the beginning, in its beginning, by the AUC, the American University of Egypt, and then it is currently conducted under the auspices of the Arab Academy for Science, Technology, Maritime and Transport. Dr. El-Haggan obtained his fellowship of the CIR early since 1995 and is in the list of the CIR approved tutors examiners since 2002. Dr. El-Haggan was also the representative for Egypt, the DRBF, the Dispute Review Board Foundation, the DRBF, so he was the representative of Egypt from 2010 to 2015. And he has conducted numerous training programs, not only in Egypt, but in the Middle East, and participated in the FIDIC and ICC FIDIC conferences in many countries, including in New Delhi, Bangalore, and Lagos. And usually in the different conferences, he achieved the highest grades when there is an evaluation of the different speakers in the different conferences. Dr. El-Haggan obtained his PhD from Sheffield University in England in 1978, and then joined the well-esteemed of Arab and Partners London. In 2012, Dr. El-Haggan obtained the Bono Thinking CORT accredited certified trainer, Oxford, England, and since 2001 made nationwide efforts via El-Haggan Teaching Thinking Foundation, declared in February 2012 to establish CORT thinking tools in the educational curriculum in Egyptian government schools. I will give now the floor to Professor Sherif El-Haggan. Professor Sherif, you will have almost 2 hours, let's say an hour and a half, in order to provide us with all your thinkings and the rich content that we all expect. I see that there is a very high number of your followers who have registered to this distinguished hybrid event. We have several distinguished attendees who are the most welcomed, who came to attend physically at Corsica premises, perhaps for the first time since the pandemic. And we also have hundreds of people who registered on Zoom today to follow you. And hopefully we will give them at least half an hour to ask you some questions about your distinguished speech. I give you the floor, Professor Sherif El-Haggan.
Thank you very much, Dr. Ismail, for the introduction. I just added this before I left home because for me it's a celebration of launching dispute boards by Cairo Regional Center. And for me, it's 20 years since I was first selected as a dispute board member in 2001. So being very old, 20 years, you know, seem nothing compared to some of the young people sitting here. So I'll consider this I'll treat this as a sort of celebration, personal celebration for this achievement. 20 years, first time was a project for water authority in Alexandria, followed by many others, thank God. I'll begin with a non-classical introduction. This guy, this book I bought years ago, John Paris. It's called Arbitration, simply. He wrote many books, but this is the first book I bought on arbitration. And he points to a painting in your castle museum that was painted in the 15th century. We're talking about 500 years. I simulated this painting. He doesn't put a copy of the painting. First time I visit UK, I must visit this castle museum and take the photo. But I simulated the picture, as you will see now. And he said in the book, don't litigate, arbitrate. Now the picture he pointed to, as I said, is 500 years old, almost, maybe more now. And it shows subject matter in dispute and the disputants who went to court while the lawyers were milking the cow. That's not me. That's 500 years old. You can't even talk to the guy who painted it. He's dead a long time ago. But the idea is that I use, it's not about the lawyers. The idea is that 500 years ago, there was a culture of using arbitration, and the Arab world waited until 1994 until we issued our law of arbitration. It was followed by many other countries, Syria, Jordan, Emirates, etc. So it's a culture, by the way, about resolving disputes. Do you really want to resolve the dispute or want to prolong the dispute? My experience is very negative in this manner in Egypt and the Arab world and many other countries in Africa and Asia, to be honest. Yeah. To me, the conclusion of this lecture will be, first time I give a conclusion, based on what Paris said, arbitrate, don't litigate. I will say certainly don't litigate. Adjudicate, then mediate, if necessary, before you arbitrate. And I didn't really invent this. It's actually the layers of resolution of disputes in the 1999 Red Book of the FIDIC. Let's see another kind of historical matter. This is the claim of publications on arbitration, in my opinion, of the Chartered Institute of Arbitration. Now, the Journal of the Chartered Institute. A few years later, it's called of the journal. A few years later, it's called, or they name it, the International Journal of Arbitration, Mediation and Dispute Management. The subject matter was only arbitration. In 2001, 5-6 years later, there was a very important section on mediation, which they consider to be at the heart of dispute resolution. Mediation, not adjudication and not arbitration. So this is progressing, the world is progressing. While mediation is not very popular in the Arab world, and many other countries I will add, and it's sometimes used as a, to waste time or to learn about the other parties' opinions. Mischievous. The FIDIC 1990 suite, in a nutshell, it has 5 layers of dispute resolution. The first is subclause 3.5, where the AG endeavors to reach agreement. The nearest to this is mediation. Mediation, conciliation, call it whatever. And if he doesn't succeed, he issues a fair determination. And fair here is essential because many people misunderstood the role of the engineer in the 99, because he describes and employs personnel, but he's required to act fairly. And act fairly is required by the judges and arbitrators. That's the criteria required by them. He is the first quasi-arbiter according to English law. He's the first quasi-arbiter in this contract. If a party is dissatisfied by the engineer's determination, it refers the dispute to adjudication, which is called Dispute Adjudication Board. I call it adjudication, DAB, DRB, whatever you want to call it, or CDB. That's subclause 20.4, which unfortunately in all contracts, 99 edition contracts in the Arab world I have seen since 1999, subclauses 22, 3, and 4 are always deleted. We abuse the particular conditional contract, not use them, we abuse them by deleting the most important balanced things in the contract. And obviously, people who are not balanced cannot produce a balanced contract. It's obvious. This is the second quasi-arbiter. I'll mention why I mentioned that later. They considered the engineer in the 4th edition of the FIDIC and earlier, similar to that of the ICE contract of the English, because the FIDIC is actually an ICE contract. ICE, Institution of Civil Engineers, England. So it's actually based on common law. It's not an international law. The FIDIC contract that's produced by FIDIC in Switzerland is, or was up to the 3rd edition, a copy of the ICE contract. Hence, it was a common law contract, essentially a domestic contract, not international. We still call it international contract. But even the FIDIC on the 3rd edition, there was the word international. In the 4th edition onwards, they removed the word international. It's not international law. It's a domestic contract. This is a fact by your own opinion. Then followed by amicable settlement. And the last resort is arbitration. So when I said don't litigate, adjudicate, mediate, then maybe arbitrate, let's see the effectiveness of this procedure. First of all, the idea of dispute boards, and it was DRB, Dr. Ismail, Dispute Recommendation Board. It was not binding nor final. And before FIDIC used the dispute board in the contract in 1999, but actually they added it to the 4th edition in 1996, an appendix that many don't know about. It started in USA in the 60s. And these are some of the projects where dispute board was used not as an essential part of a contract, but the agreement of the parties. Parties that want to resolve the disputes. They don't want to go to arbitration nor to court. أعطي الأجير حقه قبل أن يجف عرقه. Where is this from our culture and our attitude? The FIDIC 4th edition, I was appointed a member of a dispute board based on the FIDIC 4th edition, based on the appendix published in 1996. Many don't know about this. Where the engineer acted as a quasi-arbiter. Quasi-arbiter, he issues a decision which if the parties accept becomes final and binding. So that's why they don't call him arbitrator, they say quasi-arbitrator. That's according to the rulings in the common law, English law. Effectiveness. Let's see case histories, because there is a big misconception I've seen from colleagues who are supposed to be specialists in the field. I will say so-called specialists. Because the decision is not binding, it is not effective. But that applies to a party that doesn't want to resolve a dispute. It will abuse this non-binding decision by referring matters to arbitration. But let's see, since 40, 50 years ago, is it effective or not in different cultures? We'll look at projects in Africa, in China, in Europe, in England, etc., to see that really we need to develop our thinking, and our legal system, including lawyers, should attempt to not to prolong disputes. It's not ethically acceptable to prolong the dispute in order to make more money, for example. Yes, you need to defend your client only where he is defendable, not where he is culpable. Let's see this example. And let's see by actual cases, without philosophizing or talking, yes, it works. Let's see if it works or not. China. The parties agreed that the board would issue determinations. Call it whatever you want, by the way, determination, decision, it doesn't matter. It was considered to be binding but not final, similar to the FIDIC 99. 40 disputes were referred to the board. Not one went to arbitration or litigation. Although the losing party could actually issue a notice of dissatisfaction and refer it to arbitration. We'll see why later. Africa, it was a FIDIC Red Book 4th edition, and they were recommendations, neither final nor binding. Neither final nor binding. 12 disputes were referred to the board, only one to arbitration, and arbitrators upheld the recommendation of the board. Only 1 out of 12 was referred to arbitration, and the arbitral tribunal approved the decision or determination made by the board. Hong Kong Airport, very interesting. There were 6 members of the, it's a whole story, by the way, but it was 6 members, and the panel was consisted of 1 or 3 members, depending on the nature of the dispute, the complexity, etc. For nature, for example, financial, technical, legal, etc. Decisions were binding but not final. 6 disputes were referred to the DRB. 1 went to arbitration, which upheld the DRB decision. How come anybody claims it's not effective? If you don't want to be effective, you'll do your best to demolish the idea. In England, this is special. I noticed something, by the way, from my long time experience, 41 years of experience, that the common law countries are lean more towards the resolution of disputes. Mediation works very well in England and in USA. Adjudication started in USA before FIDIC, 30 years before FIDIC. And they accept the recommendation, which is not binding, non-final. But let's see in England what happened. That's why I say, that's not really defending England or for or against. I'm talking about the idea of resolving disputes. The dispute board, they had 2 sets of members by agreement of the parties. No FIDIC, no ICE, no NEC, nothing, none of the standard forms of contract. 1 technical, 3 technical, and 1 financial. Very clever idea. All chosen by any of the parties. They didn't have to go to court or to go to the center to appoint anyone. This is a positive attitude, by the way. Positive attitude. Determinations would agree to be final. Dr. Ismail, binding and final, just to answer part of your question. Binding and final. This is an attitude of parties that really want to resolve the dispute.
Final means that they cannot go to arbitration.
Yes, sir. In England.
Okay.
But by the way, the other cases that was not final, but they made it final by accepting the decision.
Yes, of course.
You see?
Of course.
That's also a good attitude. But here, They began by saying it's binding and final. This is an arbitration award.
So no room was made for notices of dissatisfaction?
Yes, sir. Alhamdulillah. Shukr. Zero disputes were referred to the board. Another project in England also. When I say common law countries, I statistically, by the way, I have data in front of me. In books, in court cases, in conferences, there was 5 members, all chosen by agreement, once again. And they agreed that it would be final and binding. They call it a determination, by the way. They didn't call it decision or recommendation. It doesn't matter what you call it. What matters is whether it's final and binding, or binding but not final, or neither final nor binding. This is what matters. I don't care about what you call it. Call it recommendation and consider it to be final and binding. Call it decision, and it's neither final nor binding. So it's really, the name sometimes is misleading. As Shakespeare said, what is in a name? The number of disputes referred to the board was 0. Very positive attitude. I met that. In China, again, 12 disputes were heard and settled, none taken further. So many examples, by the way. Talking about billions of dollars, yeah. Same in one dispute was heard and settled for a $1.5 billion project. Another effectiveness, we have seen case histories. This is facts. Now, if we don't use the dispute boards in our country or in our Arab world or Africa and Asia widely, because we don't want it to resolve disputes. The attitude is negative. Who is the cause? This is a big story that many people should work together in organizations to see why this attitude, which costs, by the way, the economy, and in my case, contractor companies, cost a lot of money. They get their money late. And I mention here a sentence in a book I used to teach in the AUC as part of the ASCE course on management, on project management. And this guy said, Fisk, his name is Fisk, F-I-S-K. He said, cash flow to the project is like the bloodstream. If we understand this, and it takes a lot to understand, we will never try to prolong disputes. Yes, defend your client, but without prolonging the dispute to dispute resolution. These are cases I was part of. I just mentioned why it works better than arbitration. I'm not against arbitration. I'm a qualified arbitrator by all means, but this is a case which shows if delayed to arbitration, it would not have resolved the dispute. One of the complaints by the contractor in this project, it's an Arab country, by the way, doesn't matter what the details are. He said there is groundwater table, which I will have to dewater, will cost money. That was foreseeable, unforeseeable. It was clause 12 of the FIDIC 4th edition. Being a geotechnical engineer, we recommended they carry out 2-3 boreholes. Within the time we were there in a site visit, 2 days, and they discovered that the water is a lake of water on a perched water table, on a layer of clay, so it's not really water table. They just pumped it in 2 days, and the cost was paid to the contractor without having to change the foundations for 6,000 buildings. So this resolved the dispute. Actually, it resolved the dispute and resolved the issue, and you don't have to go. It resolved the technical issue as well, very early enough, before even excavation started. The notice requirement, they did not agree on whether those were time barring or not. And there was a very important lecture I gave with Dr. Ismail Salim a few months ago, I think in March. No? It's available on YouTube, by the way. It was very detailed. And we issued a decision on that matter, and the 2 parties issued a note of dissatisfaction, but they followed the decision. They just issued it in order to weigh their opinion. Yeah. Now, this means that all notices that followed this decision for 5 years of the contract, they followed the decision we made. We said it's not time barring, finished. So this is the dispute over. If you save it for the arbitration after the end of the project or after 3-4 years, how many disputes will have arisen because of this matter? So that's real resolution of dispute before it arises. Not because of a clause in in the FIDIC 20.5 or 20.7 or 20.2 in the 99? No, because of attitude of the parties. Priority of documents. These guys negotiated for 6 months before they issued a letter of acceptance to the contractor, and they were lost with what priority of documents there were. There is a clause in the FIDIC, it was a FIDIC 4th edition, but there's so many meetings, which one canceled which, and which was proceeding, which was, and we issued a decision which they used for the rest of the 4 years of the project. This is resolution of dispute before it arises. This is the case I told you about briefly, Dr. Ismail, before we started. In this case, we requested the parties to agree we will get 120, not 84 days to resolve this dispute. And they asked us to issue a decision regarding what is a variation that includes overheads and profit, and what is the percentage of profit, what is damages that does not entitle the contractor to profit, and what's the overheads side and head office overhead. A very detailed, and it was a very good presentation by both parties. Since we issued this, 253 variations were issued by the engineer. Only one was referred to us as a dispute, which means that this decision resolved disputes related to 252 variations. Does it work or does it not? We have seen so many cases now. So I don't know how a colleague will say, because it's not binding, it doesn't work. But all the cases were not binding except the English cases, and it worked. Why do we have disputes? I'm always asked, why do you have disputes? Why don't you have a contract without disputes? It's impossible to do that. Impossible to do that. I ask every colleague of mine to read the 2 pages introduction to the EPC Silver Book 1999. 2 pages. I start my CLEC 30 program on FIDIC. Since 3 years ago, I start by reading these 2 pages to drive a very important message through. A balanced contract is for the benefit of the employer, not for the contractor. And this is written in so many textbooks. But many think that claims are for the benefit of the contractor. And I wonder how economically they can think of that. I can discuss this for half an hour with anybody, but not in this lecture. There are disputes because there are events which entitle the contractor to submit claims to the employer or to the engineer. And if these claims are not resolved, they become disputes. Okay, why claims? Why do we need to have claims? This slide should be why do we have claims in the contracts? Because the application of principle of sharing of risks, as is written in this introduction of the Silver Book, is for the benefit of the employer and contractor. And it says, because the Silver Book, the contractor owns the impact of 25 risks, of 25 risks, yes, compared to only 20 in the Yellow Book, only 5 risks difference. FIDIC say, not me, not my personal opinion, FIDIC say the contractor will raise his price, and rightly so, to the extent that sometimes the project becomes not viable. Only because of 5 risks transferred from the Yellow Book ownership of the owner to the contractor in the Silver Book. That's the main difference between the Silver and Yellow Book, by the way. So let's see this book. This is one of the books I mentioned, for whose benefit are claims provisions inserted in construction contracts. The origin was to satisfy 2 essential aims of employers, not of contractors. I am talking about engineers, contract managers, quant surveyors in Egypt and the Arab world, lawyers. Of course, claims provision will for benefit of the contractor. How come? The contractor incurs an event. He submits a notice of a claim, then a claim. And the claim, if the engineer is acts in good faith, he will respond in 2-3 months and pay him his money in 2-3 months, part of it or all of it. During these 3 months, the contractor is working, spending money on this event and other events. He gets his money late, and even if he's paid 5% interest, which usually is not, he paid the banks for 15-20%. So how come is the claim provision for the benefit of the contractor? It's completely for the benefit of the employer. Let's assume, I wasn't going to talk about this, by the way, but it's very important. to keep the contract in place and to allow the employer to order variations. Variations are an essential part of contracts. I have seen projects with 200, 250, 260, 300 variations. This means that the engineer did not do his design properly, and he's correcting his design by using variations. A variation would sometimes result in additional cost, additional time, and hence the contractor will make a claim for cost and time. If you prevent from making the claim, you have to prevent the employer from issuing variations. If you prevent the contractor from claiming additional costs and time because of correcting the errors in the design given to him by the employer in a traditional contract and prepared by the engineer, by a consulting engineer, many reputable, let's say large, not reputable. If you prevent the contractor from asking for a remedy for additional cost and time because of these variations, 250, 260, can you imagine? A 2.5-year project with 250 variations. That's a variation every week, or 2 variations every week. If you prevent the contractor from claiming time and money, you must prevent the employer from issuing variations. This means that this project will never be complete till the end of the world, because some of the variations or many correct the errors in the design. Or you accept that the building is built with errors in design, with possibility of what collapse and all this. Without variations, without claims, you have to cancel the power of and the authority of the employer and the need to order variations. Adjudication. Statutory, state, and again, the first country that made this legal, a legal requirement was England again, and contractual. Let's look at the statutory. It's very interesting, by the way. This was based on the Housing Grants Construction Regeneration Act 1996, which was a reflection of the recommendations in this report, Constructing the Team. I advise every colleague, whatever his specialty, to buy a copy of this book and read it. It's a report prepared by Sir Michael Latham in 1994 with representatives of all parties related to construction, employers, specialist contractors, subcontractors, main contractors, engineers, architects, etc. Very important report. He recommended that we use adjudication, they use adjudication to deal with poor cash flow, delay in payment of certificates by, of course, by the employer. He pays the certificates. And by the arbitrary withholding of money is due to reasons that are not correct. And this is the adjustment in the law, 1998. The decision of the adjudicator, this is very important, especially for lawyers, by the way, shall be binding until finally determined, etc. And binding, but not final. Let's see what the courts did to support this method of resolving disputes. It's silent on what happens. It says binding until finally determined by legal proceeding, arbitration, and agreement parties. It was thought that the successful party may have to obtain arbitrator's award similar to the FIDIC 4th edition and 1919 edition, by the way, related to the dispute boards. If the party does not satisfy, does not is in breach of enforcing the decision, the other party has to go to arbitration. So they thought that. It was so because the law is silent on this matter. This is very similar to subclause 20.7 of the FIDIC Red Book and the 21.7 of the FIDIC Red Book, 99 and 2017. On the first occasion, the successful party applied to the courts. They decided that summary judgment could be used to enforce the agreement. They did not oblige the winning party to go to arbitration. And as you know, with the legal system in England, that became the law of the land, precedents. Applications to courts were considered within weeks, not months. Certainly not years and tens of years. You know about the legal system in Egypt for whatever reason. Some cases, commercial cases, take 10, 15, 20 years to resolve. These are court rulings in England on this Housing Regulation Act adjudication for resolving disputes. Let's compare these rulings summarized. An adjudicator's decision is enforceable by summary judgment and shall not be stayed by challenge that the dispute is referable to arbitration. These court rulings, يعني law of the land. If an arbitrator makes a clerical error, he is empowered to make a correction. Aren't all arbitration rules have the same provisions? Egyptian law, CRCICA law, ICC, etc. Ancestral rules. It was held the adjudicator would have similar power. So they actually said the arbitrator in the Arbitration Act 1996 has its power, so they gave it to adjudicator, who issues a decision within 28 days in the law, by the way, not a year or two. Of course, for much lower fees than arbitrators, and much less representation by lawyers in arbitration. So only one adjudicator is selected for each case, not for the whole project. It's financial, you choose a financial person, technical, legal, etc. So one adjudicator, he gives a decision within 28 days in the law. Isn't this similar to the Arbitration Act in England, correction of the award? Isn't this similar to the ancestral arbitration rules or any arbitration rules that we know of? And that's why I say that the adjudication rules are much nearer, closer to arbitration rules than to any other ADR. عشان كده بقول هيئة مش مجلس. That's another case. A dispute arose when a claim had been notified and rejected. And the court held that the adjudicator had jurisdiction because when the claim is rejected, it becomes a claim. When rejected, it becomes a dispute, as we will see later. And as is given in the definitions in the dispute boards of CRCICA, with one minor comment I mentioned later. The adjudicator award was not wholly unenforceable. And the court had to decide whether this is excellent. This is really shows an attitude of the courts, of the judges, not of the parties. The court had to decide whether it should itself decide or refer it back to adjudicator. So the ruling was the court considered time would be saved in referring the matter back to adjudicator. They issued the decision. They are more learned about the decision. They will issue a faster decision to correct whatever errors in the court. This is a court ruling. But the court decided adjudicator's error would not prevent the court from enforcing the adjudicator's decision. For example, in Egyptian law, arbitration law, is an error in applying the law apart from matters related to public order or interpreting the contract a matter for annulment? It is not. The defendant argued the adjudicator made an error of law, an error of interpreting the law or the contract for that matter is not a cause for annulment of awards in Egypt, in the Egyptian law. It's not mentioned in the causes for annulling a contract. It's the same, by the way. I'm just comparing the rulings with Egyptian law, with ancestral rules, with different jurisdictions. Contractual adjudication. Now, statutory is over. Types of boards, and this is misleading, but I have to give it like this. That's in the books. Dispute Review Board, they call it DRB. It issues a recommendation, which is usually neither final nor binding. The DEB of the FIDIC is binding but not final. And the combined is a mixture of both. It's ICC rules. It's rarely used, by the way. I've seen it used in one project in Egypt because the contractor was French, proposed it to the employer, and the employer agreed. So because they are French, they use the CDB. Apart from that, I've never seen it used. Usually what is used is what is mentioned in the FIDIC. Why should they leave the procedure rules and the provisions of the FIDIC and use another? Like I used it here. I was a member of the board in one of the major projects in Egypt. We issued 8 decisions, by the way, and the 2 parties issued notes of dissatisfaction for the 8 of them. And we received 16 notes of dissatisfaction. A year later, we learned that they actually upheld the decisions as they are without any modification. They only negotiated the price of steel based on a dissenting opinion which I published. So I advise them to do something dissenting opinion, and they use this dissenting opinion in an amicable settlement to reach a conclusion. So the norm is DAB, the decision is binding but not final. What is not binding but not final is a DRB. So what is a binding and final decision, like the England thing? There is no name for it. So I said, don't worship the name. Just read the rules or the clause and see if it's binding, not final, or binding and final, or neither binding nor final. This is really the most important part. So forget about the name. Can be misleading. DAB is binding but not final. But in one project in Egypt also, and it's over 5-6 years ago, in the conditions of particular application, it was written is neither binding nor final. So don't be misled by the title. The parties jointly appoint a DAB. This is an advantage of DAB or dispute boards in general over arbitration. In arbitration, you select one person, and the other two are you have no say in them. But in the dispute board in the FIDIC and in most conditions of contract, by the way, standard forms, a party appoints, nominates an arbitrator, not appoints an arbitrator, the big difference, and sends the CV to the other party to approve. So there is a say for the other party. And the other party nominates a member and also subject to approval by the first party. And then usually the four of them, the two members and the two parties, work together to select the chairman of the DRB or the DAB. So the role of the parties in selecting the three members is much more active compared to arbitration. So the acceptance of the decisions it's much higher. Not only that, when we go for the first site visit and a dispute is referred, they study the dispute carefully and they see if the tribunal, I call it tribunal, هيئة فض النزاعات, as opposed to مجلس فض النزاعات, because as I said, it's nearer to the arbitration, as you have seen already, than any other ADR technique. They see the decision, whether it's reasoned, properly reasoned, حيثيات ممتازة, they begin to trust the DAB more. With every decision, the trust increases. And that's the reason for the success of the so many cases or projects we have seen before. In the 2017 edition of the FIDIC, there is something called informal assistance or informal referral, as we say. This actually exists in 1999, but it is elaborated in 2017. If at any time the parties so agree, they may jointly refer a matter for its opinion. This word opinion has become a whole sub-clause in the 2017 edition. So it became a whole sub-clause, but the word opinion is the same that is given in avoidance of disputes. It gives a role for the DEB, or they call it DEAB, avoidance. Again, it depends on the will of the parties, by the way, and the attitude, not on the name. Call it DRB, DEB, DAAB, or D7ASB. It depends on the attitude of the parties. So this informal assistance, actually, you have seen it years ago in the ICC rules, but instead of informal assistance, informal referral. Informal assistance with disagreements. So this power was given to the CDB of the ICC years ago. It's very important to have an appointing entity mentioned in appendix to tender. Because when you appoint or nominate a member and the other party does not, you can't go to court. In most countries, you can't go to court to appoint a member. So if you don't have an appointing entity and the other party, usually the employer, doesn't appoint a person, then you're stuck. It's as if the clauses are deleted. I faced so many cases, you know, when we sent the name of the guy, they don't respond. Show me the appendix to tender or special conditions. There is no appointing entity. But if there is an appointing entity, for example, Cairo Regional Center, then you can refer the matter to Cairo Regional Center, who will appoint exactly as they do the arbitrator with a dispute board member, or with the chairman if the parties don't agree. In the absence of appointing entity, FIDIC or whatever, and I hope with time, you know, we have this, you know, list of adjudicators, and we do, you know, exams and this, like we do with the arbitration. And any good arbitrator can act as an adjudicator, by the way, for that matter. Yeah. the decision, as we said before, shall be reasoned, and this is a cornerstone. حيثيات يا جماعة. And that's why if the decision is well reasoned, and of course has been well presented by the parties, then the party trusts the procedure, the process even more, and they refer more disputes and trust and it is binding. And it must be binding, in my opinion, in places like the Arab world and other countries. If it's not binding, then the party that lost the case will not be bound to that. Sometimes they lose the decision, it's against them, and it's binding, and they don't fulfill the obligations. Can you imagine if it's neither binding nor final? So it must be binding, but of course must be also not final. Unless the parties agree it's binding and final, I think we still have tens of years to reach this stage. If the party is dissatisfied, it issues a notice of dissatisfaction, in which case it's still binding, but the other party may refer the dispute or either party to arbitration. Neither party shall be entitled to commence arbitration of a dispute unless a notice has been given, which means that issuing a decision and the notice is a condition precedent to referring matters of dispute to arbitration. Yes? If the parties are silent for 28 days or whatever number of days, I mean, it may vary from one contract to another, then it becomes final and binding. That's equivalent to an arbitration or actually a court of appeal ruling. يعني قرار بات إذا جاز التعبير. This is very important. If the decision is binding but not final and a party issued a notice of dissatisfaction, then the other party has to go to arbitration. It becomes final and binding, and the party that lost the case does not fulfill its obligations, the other party goes to arbitration as well. What's the difference? A question, if you like to contribute. What's the difference to arbitrations? In the second case, where it became final and binding, you refer only the failure to arbitration. Yani a quick summary case, one arbitrator just to give you to issue an award, so you can use it, go to courts according to the Egyptian law of arbitration. But in the first case, where it's not final, it's not final, you refer the case to arbitration, but the subject matter of dispute is decided by arbitrator. There's a big difference between being binding but not final. Subject matter of dispute will be studied by the arbitrator. If it's final and binding, only the failure shall be referred. زي كده الاستئناف بالنسبة للابتدائي. You reopen the case. The DB members, yes, same as arbitration, by the way. I always believe that the quality of arbitrators makes or breaks the process. Arbitrator adjudicator. The quality of the arbitrators. Not because he's a friend, not because he will represent me in the case. He will act as my lawyer from within the tribunal. Also, the presentation of the case is very important. Can you imagine a case with, let's say, 30, 40 claims by a contractor, 15 counterclaims by the employer, with so many complications, right? Delays, concurrent delays, time-barring provisions, etc. An arbitrator will look at this case in 4 years' time after the end of the project, after the time for completion, and the parties will never be able to accurately or any near accurate present the case. Compare this to a case-by-case presented by the party during the lifetime of the project in the site, so they can visit the site and understand any matter of dispute or do any investigation necessary to discover the matter while everybody is available. So the presentation of the cases for DB during the life of the project is far more superior, accurate, better, not 100%, than an arbitration case with all these 50, 60, 70 claims and counterclaims in arbitration. Because the presentation is better, and if the three members are selected properly, you get a good, not perfect, of course. I mean, as good as is humanly possible. Nothing is perfect. Nothing is called maya maya. An arbitrator is like a judge, of course, must act impartially. It's required by law, by decency, and in my mind, by the Sharia, Islamic Sharia. Take it whatever. Take the three together and see the burden on you when you represent a party. Even worse, an arbitrator, by the way. The arbitrator or judge should not be a servant of the party that appointed him. Functions, quickly. The DB is appointed at the commencement, usually a number of days after the letter of acceptance. It's available. It's given all the documents of the project, especially the conditional contract. It studies the contract. Every progress meeting, monthly progress meeting is sent to the members, wherever they are, by DHL, by email, both. The comments of the engineers, so they are alive, they are actually part of the project. This is real, by the way. I'm talking about from personal experience. They are part of the project. And even when they go for the site visits, a presentation is made, we have lunch, we have dinner together. So gradually, even the personal relationship creates a more confidence in the process. There are regular visits, which is very important. They become part of the project. This is a fact. And they prepare decisions in a timely manner, thus preventing accumulation of claims. In a case of the ICC, I was reading a few days ago, summary of the arbitrators ruled they have no jurisdiction for a proper reason. But by this, they did not rule on 216 claims. Can you imagine an arbitration case with 216 claims and maybe 50 counterclaims by the employer, whether they are real or created or whatever? Can you imagine this as make a decision on a claim by claim basis, on a case by case basis? Obviously, a presentation of the case of one claim will be much more accurate, much better studied, much easier to deal with during the lifetime of the project. I like this. I took this, I copied this from a book. It's real-time dispute resolution. I've been there 20 years, by the way, and I can promise you that. The promise encourages a win-win than a win-lose philosophy. In my experience, there is no win-lose. If there is no win-win, it's actually a lose-lose. Think about it. Yes, the employer makes 80 pounds and the contractor loses 80 pounds, the employer loses 20 pounds. It's not 100 and 0, by the way. And if these 20 pounds is related to the quality of his real estate development, and thus clients will be unhappy with the product, the cost of the maintenance will be longer, the lifetime of the project will be short, his reputation in the market, which is nothing to do with the contractor. Your own reputation, that's by the way quoted from books on risk management. Your own reputation you have to live with. You can't insure on it, you can't transfer it to a subcontractor or a supplier or to an insurance company. Your own reputation as a person or as a company or as an entity. So the loss made by the contractor, if part of it is reflected on the quality of the project, then your own reputation is lost in the market, and actually you have given your competitors an edge because of your lousy management. Risk, that's risk management, by the way. Decisions not implemented may form a bit, and I've seen that, by the way. Many decisions, including the Channel Tunnel, one of the decisions was not enforced, but the parties used it with the reasoning to reach an amicable settlement. That's why in the FIDIC contracts and all the other standard forms, after the decision of the DEB, there is an amicable settlement step before going to arbitration. Sometimes they use the decision with its reasoning to negotiate a settlement. So it becomes a reason for the settlement. The decision is a condition precedent to referring to arbitration, as we said. The decision is admissible as evidence in arbitration. So a party that's in breach, when they go to arbitration, they will see that this party lost the case but did not fulfill the obligation, although the decision is binding. That proves to the arbitration tribunal from the first presentation that it doesn't act in good faith. A binding decision that has not been obliged with for the last 2 years, for example. The reasoning is a cornerstone. The reasoning is the main reason why the decisions or the DB works. Procedure rules, that's the last part of the presentation. I used the procedure rules of the 1999 edition of the Red Book, which are almost the same as the 2017 procedure rules. Let's compare to arbitration. Okay. فقه مقارن. The DAB shall proceed according with subclause Kaza and these rules, and shall act fairly and impartially, obviously, giving each of them a reasonable opportunity. I am not for reasonable opportunity. Our law says full opportunity, as taken from ancestral rules. The Arbitration Act 1996 says reasonable opportunity. Which is better in your opinions? I want to know your opinion, especially people involved in arbitration. Full opportunity is almost impossible to do, and gives the party that wants to prolong the dispute in arbitration to do that. No, I want 6 months to prepare my statement of defense, not 3. I want 1 year. And if you don't do that, you go to court to try to annul the, because you didn't give me full opportunity. In the Arbitration Act 1996, they said reasonable opportunity. Actually, you quoted the word full from the ancestral. I prefer the reasonable opportunity, and I don't know about the CRC rules. I can't remember.
In our future new rules,
Yes.
we are considering shifting from full opportunity to reasonable opportunity.
41 years experience, Doctor. I'm telling you, full sometimes gives the nasty party an opportunity to abuse the thing. Yes. And I read about this, by the way, a research in 1996 in arbitration. There was a comparison between the Arbitration Act 1996 and the ancestral rules. So that was very good. The word reasonable gives some control of the arbitration tribunal to control any misuse of the procedure. The DAB shall have power to adopt any inquisitorial procedure. Isn't this similar to the role of the judges in civil law jurisdictions as opposed to adversary system and the common law system? To proceed in the absence of a party satisfied he had the notes of the hearing. Very high powers, by the way. And these powers are given by the parties. Party autonomy, that's another very important characteristic of arbitration. The employer contractor empower party autonomy, isn't it? So who established the procedure? The DB. Sultan al-Arada. A dispute, it decides on its own jurisdiction, competence, اختصاص بالاختصاص. Very similar, by the way. It's as if it's summarized from the arbitration rules and court rulings in England. Conduct a hearing, etc. We usually, I don't remember issuing a decision since 2001, whether it was in Egypt, in Qatar, in Saudi, in Dubai, in Nigeria, without a hearing. Sometimes it's a very short hearing, 3-4 hours. The same procedure for the arbitration. The claimant makes a presentation, the defendant, and 2 rounds, and then we sometimes ask for post-hearing submissions. But of course, within the 84 days. And of course, it's only also one claim. It's not complicated, or less complicated than. Make use of his special knowledge, same as the civil law system, by the way. Decide upon interim measures. Yes, interim measures. This power is given to the arbitrators in the all the FIDIC contracts and IC contracts. They can open up, review the decision of the engineer, or etc. Decide upon measures relief. That's the same as Article 17 of the model law or 26 of the ancestral laws. Interim or the Egyptian law, except that the Egyptian law changed the ancestral and made it by the agreement of the parties. So actually they cancelled it because parties never agree on giving this power after the refer to arbitration. So in this case, if they don't agree, they have to go to court. But the ancestral, which we which is the essence or the main source of the arbitration law, in the Egyptian law, they canceled this power to a tribunal and gave it to courts, and they said they must agree. When did you see disputants in Egypt or other similar countries agree on anything after arbitration is commenced? It shall endeavor to reach unanimous decision. You are reading actually arbitration rules here. Those who are familiar with arbitration. And if not successful, by a majority vote. Ancestral Article 29. If a member doesn't attend, the 2 other members can proceed with the meeting in order not to waste people's money, etc., except in certain circumstances given in the procedural law. So the procedural rules are very similar, by the way. Ancestral rules, model law, ICC rules, CIRCICA rules, Cairo, Egypt law, Arbitration Act 96. Similarity is very obvious. Thank you.
Thank you very much, Professor Sherif El-Haggan. It was a very informative lecture. And as we are usually used by hearing your lecture, it was very well explained, very simple, to the point, very informative. Perhaps before giving the floor to the attendees, whether online or those who are physically attending with us, I would like to ask you a few questions. So, can you cite, if there is no confidentiality obligation, some projects in Egypt which have used the dispute board mechanism?
Only when we are forced to.
Yes.
Yeah, I mean, usually World Bank supervised projects, except one case where there was a private bank in Egypt on a big project, big government project, yeah. But only when clauses 22, 3, 4 are almost always deleted in all 1999 edition contracts. And that applies to the top contract management companies in Egypt.
But I heard that the new airport at the time, of course, the Terminal 2 airport
And 3.
and 3.
And Hurghada and Sharm el-Sheikh. And I was a member in all of them, by the way.
Okay. So
They're over for the last, I mean, the last one was completed about 5 years ago. So there's
So usually when we are building a new airport in Egypt, usually there is a dispute board. We can say that.
I know about the 4 cases, but there is an airport which doesn't have a dispute board. But it's current. I don't want to give the. I mean, it's one project.
Okay.
But also it was used in other projects, like for example, Nagah Hammadi Barrage.
Yes.
And a few years back, Asyut Barrage.
So the Asyut Dam, yes?
Yes.
I also heard, but I would like to know, to have your confirmation. I understand also that in the field of PPPs, we are now starting to see some dispute boards.
Yes.
So not in the purely construction projects, but also
Yes.
in the
Sure.
PPPs
It's
contracts.
increasing, but very slowly. In England, I would say surely and slowly. Here, I would say slowly without surely. Unfortunately. I know that doesn't please some people, but I'll say what I have to say. I'm responsible for what I say.
Okay, before giving the floor to the attendees here, there are some few questions that were asked by those who attended, some of the remote attendees. So from Mr. Sizo Sameh, what is time and material contract?
Time and material contract? I don't know. It's not. This is not related to the lecture at all, yeah. But I don't know what's time and material contract.
Okay, another.
That's an answer, isn't it?
Yes. Another question. From Mr. Mahmoud El-Khamri, can the contractor resort directly to arbitration without referring the claim first to the engineer?
Maybe he's talking about the 4th edition of the FIDIC and earlier editions. No, the referral to the engineer with dispute is a condition precedent to refer to arbitration, same as the referral to dispute board in the new editions, a condition precedent to refer to arbitration. And actually, I know many ICC cases. I'll send you one as a small gift. It's published, legally published, that the ICC Tribunal Court considered it has no jurisdiction because the contractor did not refer the 216 claims to the engineer for his decision on clause 67. So it is a conditional precedent. I'm talking about the FIDIC, but any other contract will be subject to its provisions, of course.
Another question from Mr. Ramprasad Ramasamy. Engineer being an employer's agent under FIDIC 1999, how come engineer can make fair determination under subclause 3.5?
How come the engineer under the 4th edition of the FIDIC be required under subclause 22.6 to act impartially? Who says that the engineer should be immoral person? Who said the engineer, whether he's an employer's personnel or agent or whatever, should say the wrong thing and does not grant the contractor his dues only because he represents? Who said that the employer himself should not give the contractor his own dues? This is the requirement, by the way. If he doesn't fulfill it, he's in breach. Not only is in breach, his reputation in the market will be very good with employers who want to prolong paying the contractors. So he will get more jobs. Unfortunately, again, he's required to act fairly. Same as an arbitrator, by the way, is required to act fairly. And if he doesn't do, the cash flow is disrupted, the project disrupted, the project is delayed. And when the project is delayed and quality is lower, the employer suffers as well. I said win-win against, I mean, the equivalent or the other part of it is lose-lose. Many people say win-win, not win-lose. It's win-win or lose-lose. If an employer loses his reputation in the market, that's his own reputation. Because he, for example, didn't pay dues, because he didn't do good supervision, etc. Who bears with him this risk? Only him. If I go to my lectures late every day, every time, I cannot insure on that. My colleagues will say this guy is negligent. He doesn't give us our service properly. He doesn't care about our time. I'm giving a simple example here. If I go once 5 minutes late, 10 minutes late, incidental every year or two, I apologize, but I'm almost 5 minutes early. The traffic, Google will tell me it's 1 hour. Google told me it's 1 hour. So I moved 1.25 hours and came at 6 o'clock. I know it will begin 6:30. So I came here 45 minutes early in order to avoid any traffic incident in the road. Really, it said 65 minutes. I moved at 4:45. And I planned to come here at 6, and I was here at 6. And I know there's still half an hour. Yahya wants to adjust something, something wrong with the internet. I don't know what will happen, incidents. So this is risk management, because I respect the guys who will come here and who will attend online. And if I don't do, over the time they will not attend, they will not take me seriously. I'm just giving an example. Your own reputation as a person, as an entity, as a lawyer, as a company, you cannot insure in that. You cannot transfer your own reputation as an employer abusing the conditional contract to the contractor. And the contractor cannot transfer this to the supplier or subcontractor. You live with your own bad reputation. And that's why I said the opposite to win-win is lose-lose, not win-lose. Please think about it, on your way home.
Thank you very much, Professor Sherif El-Haggan. Indeed, I really like your statement that it's either win-win or lose-lose.
Yes.
Two partners in a contract implementing it in good faith, they would both be keen on ensuring that both sides are winners from the contract or the relevant transaction.
And that's why Dr. Sherif started with the cases, international cases. It should be the closure of the lecture, by the way. But I started to show you that it works, even when the decision is not binding and not final. It depends on not the will, on the morals of the parties, or surely on the understanding of the parties of the economic value of the project and their future relationship and the reputation in the market.
But to go back to your preference of the dispute adjudication board mechanism versus the dispute review board mechanism, because the former is binding from the beginning, although it's not always final, because either party may send a notice of dissatisfaction, whilst the latter will not be final and binding until a notice of dissatisfaction is sent. But if we say, I'm defending another argument, if our employers in our region are not yet used to dispute boards in general, why not starting with the less binding between both of them and starting to encourage dispute review boards as a beginning, if the concept in itself is not accepted? So it's a midway step to start promoting DRBs until it is in the culture, and then we can further promote dispute adjudication boards.
If a party does not fulfill its obligations regarding a binding decision, and it forces the other party to go to arbitration, although the decision is binding, do you think that they will, in good faith, accept a non-binding, non-final decision? If they want to accept it, they will accept it even if it's not binding and not final. But if they don't even if it's binding and final, by the way. We have seen, I've shown the English cases because they agreed from the beginning, we're not going to arbitration. This is the attitude. But I have seen cases, by the way, going to arbitration, although they were binding and final. And the party that lost the case did not fulfill. So why do you believe that a middle of the road solution will resolve the issue? We need to change the culture of the society, actually. I think we need moral lessons and economic lessons. I think so. Where is mediation in Egypt? I took part in the mediation law, okay? And yes, and I was invited to a meeting with many colleagues, by the way, in the Ministry of Justice. And I wrote many comments for the chairman of the, and he told me, you're the first person to give me comments in writing. And why don't we use mediation? It's available without a law, by the way. Why don't we use the mediation? Because we're not acting in good faith. Why do lawyers move to another part? Some lawyers are professional in attacking arbitrators and removing them from the tribunal. But if you remove an arbitrator, whether he apologizes and leaves or by court, another arbitrator will be appointed, and he might be worse than the person you removed. You're prolonging the dispute by a month or two, not by a long time. Yeah. Some lawyers' reputation in Egypt now, and their names are known, they are professional in doing this. That's the first step they do. So do you think they will accept a non-binding, non-final decision? So if they are willing to accept a non-final, non-binding, why don't you accept the binding, non-final? I mean, why do you think they will accept it if it's not binding or not final?
Anyway, it's a long debate.
We are giving them, if the binding final is not fulfilled, then the non-binding will be even further or more not fulfilled, and thus we're giving them a license to kill. That's my opinion.
Thank you, Professor.
And my experience, by the way.
Yes, of course, of course. Anyway, it's a long debate whether we should recourse to DAB or dispute review board. I will give the floor in the order of raising hands. So now we will give the floor to those who attended physically, and then we will go back to the virtual or remote questions. Dr. Khaled Atiyah has a question to ask to Professor Sherif.
Thank you, Dr. Ismail, and I would like to thank you for organizing this event, and I'd like to thank Dr. Sherif for the valuable and very informative presentation.
Thank you for coming and accepting the invitation.
Always a pleasure. Actually, I have two questions, not one. The first refers to the opinion that you have referred to in the 1999 petition and the informal assistance referred to in 2017. Comparing this to the arbitrator and the judge, if you give an opinion or an informal assistance, this qualifies me.
Of course.
As a judge or as an arbitrator.
Yes.
How would this work with the DAB if the board gives an opinion or an informal assistance? How would you qualify this?
Yes, that's why I said there is a wide powers granted to the DAB than to arbitrators. That's one of the reasons you touched on a very important matter. The arbitrator opinion will be known in his own award. That's it. Before that, he risks being removed. Yes, and he doesn't become impartial. But he's required to be impartial, but he will give an opinion if required, if asked by the two parties. I'll give you one example. In one of the airports, doesn't matter which one, they had disagreement over whether to value some variations using day work rates or not. And the contractor had 7 heads of claims and another 7 points. And then the employer asked the contractor in a site visit meeting, do you mind we ask this guy and that guy in their specialties here? So they asked me about regarding using the day work rates and variations. And I said, let's, with the computer, let's read the clauses together. So we read them slowly as we do in CLEC. And the contractor said, no, I'm not allowed to use it. He said the question, answered the question. So sometimes they ask about geotechnical matters like I did, or a structural engineering matter. If they agree, but the opinion is required in the FIDIC, whether 99 or 2017, whatever you say in the opinion does not bind you when you give a decision. Because when you give a decision, you receive documents. I mean, here it's a verbal thing that happened during the meeting, maybe a very brief letter or something. But when you give a decision, you have a statement of case, statement of defense, hearing experts sometimes, so you learn more about the issue. How come we have made ARB in USA? Why doesn't it work in Egypt? Because of a silly legal reason. Why does it work in USA and doesn't work in Egypt? Because the mediator was learned about the dispute. So what يعني? Why do you keep creating hurdles, for resolving? But I enjoyed the question.
Thank you. And I have another question that is related to the full opportunity or reasonable opportunity.
Dr. Khalid, sorry to interrupt you, but I want to elaborate from the Corsica rules to answer also your question. Perhaps you have read Article 13, Paragraph 3, and this has triggered your question. If the dispute board is required to issue a conclusion, so a decision, whether a recommendation or a decision, regarding any matter on which it has earlier provided an informal advisory opinion, the DB shall not be bound by any views, whether expressed orally or in writing, which it may have given during the course of its informal advisory opinion. So it does not affect the impartiality. This, of course, cannot happen in arbitration.
Yes.
You will be automatically.
Cannot happen in arbitration, nor in litigation.
Nor in litigation, of course. But under the various dispute board rules, because this is not a rule that is specific to Corsica rules, it exists elsewhere also. A dispute board member can provide an informal advice during the phase of dispute avoidance or whatever, and then the matter escalates and becomes a dispute, and then a DRB or a DAB will be constituted and may decide upon the same issue, and in this case, the dispute board members will not be bound by the informal opinion that was given before. This does not affect their impartiality. In my view, perhaps because it's a contractual mechanism and there is always a room to send a notice of dissatisfaction and refer the matter to arbitration. So I think this is balancing between permitting the dispute board member to play the two roles, dispute avoidance, knowing very well the project, and then being able to adjudicate the disputes through a contractual mechanism, and it is not a final decision anyway, unless it is not opposed to, or there is no dissatisfaction, notice of dissatisfaction sent timely. So I believe this is why there is a distinction between arbitration and dispute boards, and correct me, Professor Sherif.
No, I fully agree.
Yeah,
That's
you
why
agree.
I said they have wider powers.
Yes.
I mean, if you give an opinion during a site visit meeting regarding interpretation of clause or any technical matter, you are surely, you surely would change your mind if submissions, if the matter escalates to a dispute, and this matter and the details given by the parties are much more than those given in a question during the meeting. And this gives you the chance to change your mind if there is a need, and study the case properly and give another opinion. And this, by the clause in the FIDIC, is the same in the ICC rules. It's the same now in the CRC rules. It's almost universal now because it gives more power. Do you know what happened after this meeting? The contractor sent us the heads of claims in a letter with 5 heads of claims instead of 7. That costed the parties 7-8 minutes from a day visit, which was already paid anyway. It costed them 0, by the way. So no transportation, no travel, no nothing. During the same visit, it was resolved. So he reduced, and then later he sent only 2 cases to dispute. And he changed mind about that. I don't know why he sent only 2. And we issued 2 decisions on dispute. So this assists this power or given to the dispute board members, gives them the opportunity to assist as much as possible without fearing of being accused to be unimpartial or not independent, etc. So this is wider powers, and that's why I like the question. It touches on a very important tool given to resolve dispute without even referring dispute to the dispute board. It's a 5-minute question or 10-minute letter. Give us your opinion.
Thank you very much. And my second question is about the full opportunity or the reason of the opportunity, and why not using the same provision provided under the arbitration rules, which is equal opportunity instead of full or reasonable. So why not using an equal opportunity to both parties?
Okay. Yeah, that's a new question. Will the equal be full or reasonable?
It doesn't matter.
No, it doesn't matter.
It's equal for both.
I'll tell you something. I am a claimant, and I submitted the case before. To transfer the claim, a fully detailed claim, to a statement of case will take me a few days. Let's say a few weeks. And I ask for 2 weeks or 3 weeks, and that often happens, by the way. And the respondent, say the employer, wants 5 months. I'm not familiar, but he was familiar with all the claims submitted during the 3 years, by the way. So full opportunity, if you don't give him 5 months, you risk the award being annulled. I was not given full opportunity. This is the mutlaq على فكرة. Reasonable gives the arbitrators who are experienced to say no, 3 is enough or 2 is enough or 5 is okay. So this gives more control for the parties. But equal
is bearing the arbitration rules, and it is the arbitration which is more.
I'll use my example. If you give the respondent 5 months, you have to give the claimant 5 months, but he wants only 2 weeks, he's ready. So why do you prolong the arbitration process? He wants only 2 weeks, 2 months, and he will sign. I ask for 2 months, and I accept that the other party gets 5 months. He's signed for that. So why do you want to transfer the 2 weeks or 4 weeks into 5 months to give them equal opportunity? That's why I asked you. But you only triggered the idea now, by the way. If it's equal, 5 plus 5 or 2 weeks plus 2 weeks, or 2 weeks and 5 months.
Again, it rests with the hands of the DAP or the.
It doesn't. Full does not rest with the arbitration tribunals. It rests with the party who wants to prolong the case. Full, but reasonable, and of course, arbitrators should be reasonable, or at least 2 of them will be reasonable. At least 1 of them will be reasonable. I hope. So reasonable gives control for all, but full. I prefer reasonable to full from long experience in dispute boards and that's why I think reasonable will be much better. Even arbitration law in Egypt should be reasonable, should match with the Arbitration Act, not quote directly for answer trial without studying the impact of this word. It's 1 word, by the way.
May I add to this? My professor, Professor Eric Loquin, who supervised my thesis, he wrote a very interesting article in French, but I think it merits to be translated to English and Arabic. He, according to his view, of course, the different arbitration rules provide that the arbitrators should treat the parties with equality and give them a reasonable or a full, but we should treat them with equality, should treat them equally. But according to his view, and he has proven it, that the principle of equality between the party does not exist in arbitration as a standalone principle. It is either the other face of the right of defense or le principe du contradictoire, مبدأ المواجهة بين الخصوم. So it is either this or that, but it's not a standalone principle, and a party can waive it. For example, the time limits.
Yes.
You can never say that they had exactly the same time limit. You will, you always find sometimes the defendants or the respondents, they always invoke or allege that the claimant had an indefinite number of months to draft its statement of claim or its notice of arbitration, while the respondent has limited time to draft its statement of defense. So it's a very interesting article. I do not recall it because I read it 11 years ago, or even more, 12 or 13 years ago. But he is saying, and he has proven it, according to his views at least, that the principle of equality between the parties in arbitration doesn't exist as a standalone principle. It's always part of the right of defense, whether the full opportunity or the reasonable opportunity, or the principe the contradictoire or confrontation. So each party must be aware of the evidence submitted by the other party, and it goes the other way around. So this is.
If I may comment, by the way, the word full is absolute. Reasonable is relative. You cannot really give absolute right to the parties. But in construction cases specifically, not all arbitration, construction cases, the contractor is required to send a notice and the claim for each event, by the way. And he's required to submit, for example, an extension of time claim and prorogation cost and update it along the whole, if he's doing his job properly. And sometimes he loses his right, either by time barring provisions or by lack of proof, or both. So actually, the employer and the union are never ignorant until they go to arbitration of the case, because they have rejected the claims which went to arbitration. So you know everything. So the difference between a properly prepared statement of claim, updated along the period of the contract, 2, 3, 4, 5 years, whatever, and between the statement of case will be marginal, by the way. It will be some legal clauses, some, I don't know, formality, etc. A properly prepared statement of claim will not take, however complicated and whatever the extension of time and quantum, more than 4 weeks to prepare, more than 4 weeks. And the employer obviously has been familiar because he received notices, he rejected them, then he rejected the claims, so he cannot really claim that he's not aware of everything. So when he asks for 7 months, and I'm sure as a person who prepares claims that 3 months is more than enough, full will be possibly a reason for annulment, hopefully not, but reasonable will not. Of course, reasonable doesn't mean I grant the respondent 2 weeks like the claimant wants. That will not be reasonable, and it will not be fair.
Or for example, 2 rounds of submissions or 3 rounds of submissions. One would argue that 2 rounds of submission is not sufficient. I need the 3rd round of submissions. But if the provision is that each party will be given a reasonable opportunity to defend its case, it will give more flexibility to the arbitrator or to the adjudicator.
Or whether the post-hearing submissions are simultaneous or consecutive, I mean, that's
exactly.
Yeah.
But in the Corsica dispute board rules, Article 15, paragraph 4, the DB shall be fully responsible for the conduct of the hearings, at all times act fairly and impartially, and ensure that each party has a reasonable and fair opportunity to present its case. It's not mentioned that it will treat both parties equally. It's not mentioned here like in the arbitration rules as usual, to the best of my memory. Don't blame me if we find it elsewhere.
Sometimes by the will of the parties, they don't want equality, as I said.
Yes,
the claimant wants 2 weeks. Why do you give him 5 months? I mean, you're harming him.
No, that would be up to the responsible claimant.
Yes.
So they waive the right to do so.
Yeah.
But it is for the board or for
as I asked you, equal, will it be equal, full or equal reasonable?
It depends.
So it's relative.
Anyway, thank you, Dr. Khalid. Please present yourself.
المايك مقفول.
Egyptian Council of State. I would
Yes.
Or you can ask the question here if there is another one.
I would like to ask a question concerning Article 20.4 in the FIDIC Red Book 1999. This clause already it lacks an explicit provision stipulating that the mere failure to comply with the binding DAB decision could be taken to arbitration in itself. This is contrary to the 21.7 article in or clause in the 2017. So you are already familiar with the Procedural case before the Singapore High Court, where there was an arbitration award trying to enforce the binding dispute adjudication board decision, and then the Singapore High Court annulled the award, and they said that the court exceeded its jurisdiction, and it shall refer the dispute again to the engineer, then the dispute adjudication board. So I would like to ask, if we compare this situation and we have a 1999 dispute adjudication board decision before Egyptian courts, will the Egyptian courts accept taking the mere failure to abide by the DAB decision directly to arbitration under the 1999, or will they do the same like the Singapore High Court that refused this position?
Well, you want me to advise the courts, but I'm not a member of the courts.
I want to ask, do you agree with the Singapore High
I
Court
like
or
to
not?
apply the agreement between the parties. This is party autonomy, not only for arbitration. Agreed that the determination will be binding but not final. If it's not accepted by either party, then a dispute arises that goes to the DAB. And again, the DAB decision is binding but not final. If they are silent, it becomes binding and final. Now, whether it's binding and final or binding but not final, and the party that's obliged to enforce the binding decision, whether it's final or not, did not do that. What does the winning party do? Why refer it back to the engineer? To do what? It was referred to the engineer already in subclause 3.5 or 3.7 in 2017. So why repeat the circle again? I don't understand. It's so strange for me as well. It's so strange for me as well. And if you have the whole, I have a summary of it. If you have the whole ruling, I'll give you my email to send it to me. We can talk about it over the phone.
The interim decision by the tribunal in the case of 2011, other tribunal issued an interim decision enforcing the decision. They said, well, it's fine, you can do this through interim award, but not through a final award. It's so strange, so that's why.
I find it strange as you did. And in this case, I'm changing the agreement of the parties. Is the court entitled to change the agreement of the parties? They agreed to be final and binding. And that's to me an equivalent to an arbitration award according to law 27. So why should you can see the attitude here is completely different to the English courts, which sought for every means to support adjudication. We have seen some of the court rulings in England. They sought for every means to support adjudication, and they issued their decisions within weeks, not months, certainly not years and tens of years. That will not be justice. So I agree with you. I don't understand this, but I'd like to read the whole thing, and I promise you will discuss it over some nice light music. Not cup of tea.
Counselor, may I also elaborate? I can tell you that the French courts, they consider that if a conciliation clause has not been implemented and that parties went to court directly, the case will not be admissible. الدعوة غير مقبولة. مسألة عدم قبول لرفعها قبل الأوان. So this is an established.
It is a condition precedent according to this.
Yes, it's a condition precedent. So if the mediation clause or the conciliation clause or dispute board clause, if it was agreed contractually that the parties will resort to ADR prior to litigate, it constitutes in French fin de non-recevoir, which means that the case is non-admissible.
In this case, that already there was a decision of the AEB. His employer was asked to pay some amount of money, and we failed to pay. So the contractor said, well, it's a decision of the AEB, and it shall be binding, and it's not paying. So he went straight right into arbitration. And then he got an arbitration award, which was announced by the Singapore High Court. He said it's binding, yes, but if there is a dispute against, so you shall take the mere failure to comply with the AEB decision back to the engineer and the AEB.
Okay.
So this was the stream.
To me, this is an express provision that's not ambiguous. The last line I just highlighted in blue. Subject to certain circumstances, the decision shall become final and binding.
My name is Medhat Askar. I was the former deputy chairman of Arab Contractors and former group managing director of Arab Contractors companies in Africa. I have two questions, please. It is always mentioned that the engineer should be impartial. This is written in every textbook, in all lectures and all that. But in actual reality, I've worked in the business for about 45 years. I've never seen this. It is never true. So is there any legal grounds to criticize the actions of the engineer or to even penalize him? By the way, in many instances in government contracts, the engineer was a civil servant. He was actually one of the government agents. So how can I deal with a situation like that?
Well, he doesn't act impartially. This is true. So can you remove him from the example, withdraw his license? There is no mechanism. So the only means is to raise your objections through the mechanism of the contract to his decision in clause 67 or to the DEB and then go to court. But this means that we are not resolving disputes using the mechanism in the contract because of the lack of good faith of the engineer and of the employer, by the way.
Okay, my second question, is there any restrictions or conditions on the choice of the arbitrators or adjudicators, or I'm free as a contractor or as the other side to choose whoever I want?
There is no restriction, as in arbitration, by the way. There's nothing that prevents you, as I read in a book on English cases, that in England they leave it completely open. In some countries they limit it to lawyers or etc. Or to a person who studied Sharia, like for example, a chairman in an arbitration panel in Saudi Arabia. I don't understand this provision, by the way, and I discussed it many times with Saudi colleagues. But you are free. The free will of the parties to agree arbitration and to select their judges. This is an essence of, if you put any limitations, you are removing this. But of course, no one will choose a person who's not qualified. But you are. I mean, this guy said in one of the books, read from Hunter actually, they said, when an English person saying, I can choose my tailor to be my arbitrator. I may pay the price for doing that, but I'm free. So it's the will of the parties and the free of the parties of choosing their judges. One of the characteristics of arbitration, but nobody does that, obviously.
Thank you.
Can I elaborate on the last question, or even your two questions? Regarding the engineer who is not impartial, of course, it's very difficult to measure the lack of impartiality because it's a psychological issue. So of course it can be, if you can prove it, you will only be able to prove it from external evidence or material evidence, but it's quite difficult. You can always sue any person. There is no immunity for the engineer. He can be sued, and you can ask a court to declare that he is liable for breaching a contract, contractually liable for breaching his obligation of impartiality. But this is quite rare in practice. So perhaps the best way is that the decision of the engineer can be reviewed or revisited by a dispute board if this is possible. The second,
Excuse me, but can the mere fact that the engineer is appointed is a government agent in itself is against this principle, defies the principle?
No. No. I know a person in Kuwait, I'll mention the name later, he died, yeah. Whenever there was a dispute, and he was the chief engineer of this place where I worked in, he asked myself and of course the team of the consultant to give him a proper report on the claim. And whenever there was that, he signed it as is. It's a rare case. It's a rare. I know you prefer it well done, but it's a rare case. By the way, to make you even feel more bitter, BI, not BE. Look at this. Have you ever seen it in the Arab world or in Africa? In subclause 53.2, the contractor is required to keep contemporary records. Proof, إثبات يعني. The engineer shall, have you ever seen it? I say مدحت because we're friends, by the way. The engineer shall inspect the records of the contractor and may instruct the contractor to keep further records that's material to the claim. يعني help him improving his case. Have you ever seen it happening?
No.
We all know that the engineer
is required to do that, by the way,
is the owner's representative. In reality, this is the fact of the matter.
But does the owner representative or even the owner, should he, because of the owner, not grant his the contractor his dues or breach the contract simply because the owner?
No, not necessarily, but what he really does is that he looks after the benefits of the owner, not the fair decisions. So we all know.
For example, if a contractor submitted 10 claims which were rejected, and then in each of them he was granted money in arbitration award, this means the engineer actually was not acting in good faith. I don't know if these were accepted in court or not. But this means also this engineer will be appointed by the same employer again. Because at least if the contractor is granted the money, is granted after 3-4 years. So he kept the money for 4 years until he was granted the money. And then he paid 5% from the initiation of the arbitration award, not from the initiation of the dispute 4-5 years later, back. And contractor was incurring 15-20% in the banks. So he still made money even after the arbitration award. And not every contractor will go to arbitration, by the way. So he's benefiting. But that's the benefit of believing that there is heaven and hell, by the way. Can you see this? I always in my lectures, nobody reads this, by the way. The engineer is required to inspect the records of the contractor that prove his case. And he may instruct him to keep further records to prove his case without admitting liability then until the claim is submitted. This is written in all ICE, JCT, FIDIC contracts. All the 7 ICE editions, the 4 NEC editions, the 6 FIDIC editions, this is written. I've never seen one engineer in the Arab world, for example, or for that matter in Asian and African countries, where I gave services that fulfill this obligation. And maybe some of you will read it for the first time today.
I would like to add that the Corsica rules in its Article 7 provides for the qualifications of the dispute board member. So of course, every party is free to appoint its dispute board member, and when using Corsica rules, no one would object that the dispute board member does not fulfill the qualifications mentioned in Article 7. But however, if the center is required to appoint a dispute board member because of the failure of a party to appoint its dispute board member, or the failure to agree on the president of the dispute board, or the chairman or the chairperson of the dispute board, then there are requirements. So the expertise in the type of work or services subject to the dispute. Also mastering the language of the contract. The skills to manage the disputes, the ability to comprehend and interpret the contract. And the center shall endeavor to select DB members with the appropriate skills.
So actually there are conditions here.
Especially when the center is required to appoint. And the center is required to appoint from its panel of adjudicators. Can I tell you, can I raise some questions of those who are attending virtually, and then I will give again the floor to our attendees in person. From Mr. Basim Khater, what the contractor can do in case that the client keeps on delaying the establishment of the DAB, although that the members have been selected by the parties.
If the members have been selected and signed the tripartite agreement, then he cannot delay anything. He can delay selecting a member, but in this case, you have to refer the matter to the appointing entity. And if there's no appointing entity, you've had it.
Thank you, Professor Sherif. Another question from Mr. Gerard Monaghan. Thank you indeed for a very interesting presentation. Can I ask if the Corsica Dispute Board rules are intended for general application across a range of contract forms, or they are designed to link to a particular form? May I answer this question? No, they are designed to any type of contracts. And Article 2, Paragraph 1 even gives the parties the right to amend these rules for their specific purpose.
Can I add to that, Dr. Ismail?
Yes.
It was one case, but I was selected as a sole adjudicator in a case here in CRC about 14 years ago between two parties, an employer and the contractor. And I issued a decision. I don't know whether they went to arbitration or not, but I attended here as a sole adjudicator once, even before the rules were issued. But it wasn't repeated, or maybe I'm not aware of that. I was selected as an adjudicator here in this. I hereby witness that this happened. So the parties agreed on it. They went to they referred it to the Cairo Regional Center to regulate the matter, and I think it was a 14-page decision which I issued.
I will dig into our archive.
I'll send it to you.
Yes, because as you know, we try to archive everything.
Yes.
And the Corsica in the past, at the time of Dr. Abul Amin, had a lot of different ADR rules, including fast track arbitration and conciliation rules and the different types of rules.
I'll even mention, I'll give you the name of the parties. I think I remember at least one of them.
With pleasure. It will be, I'll be very thankful to you. Of course, Dr. Sherif has a long history with Corsica since decades.
June 1995.
Since June 1995, with the establishment, or even before the establishment of
a few months before that,
the establishment of the CIR Egypt, even before that.
No, it started with the fellowship exam. So I came here before June, maybe in May, to pay the fees and all this. And that was my first real relationship. Then, of course, a long relationship with Dr. Abul Amin, who actually taught CLEC 45 until he died, since it started. He never apologized. And I ran the Cairo branch CIRB training course in Jordan with Dr. Abul Amin. Long history.
May his soul rest in peace, Dr. Muhammad Abul Amin, of course. From Mr. Hisham Hassan, is amicable settlement in FIDIC should be done before arbitration?
No, it doesn't. It doesn't have to be done. Luckily, I have the clause here with the big misunderstanding on that. 67.2. I was in an arbitration case once with the chairman saying the guys didn't attempt to resolve amicably. It was a 4th edition FIDIC, by the way. So we have no jurisdiction. He said to me over the phone, I said, this is deliberation. We need to do that with our colleague. And we visited him later in his office. It was an ad hoc arbitration. And I said, actually, he did that because he read the translation of this clause, Arabic translation. Not important to mention who the translators were, but I mean, he considered, but it was an English thing. Can you see this last sentence? Even if no attempt has been made. Even if no attempt has been made. That's obvious. So, where notice of intention of arbitration has been given, the parties shall attempt to settle amicably. The translation said, if they fail in settling amicably, إذا فشلوا شو الحل ودي. If they fail means they must attempt, but they didn't translate the last sentence properly. Even if no attempt has been made, that's a blunt, obvious, non-ambiguous provision. So it is a 56 days for amicable settlement. So the mere passing of the 56 days allows either to refer the matter to arbitration. And this is not, even if no attempt has been, I'm reading from the screen. And the same applies, by the way, in the all 6 editions of the FIDIC. So there is a misconception that there must be an attempt, to the extent that this chairman of the tribunal said, we are very lucky. We rule, we have no jurisdiction because he did attempt, because he read in that, I'll send you a copy of the translation, only this clause. If they fail to reach amicable settlement, and the word fail implies that they must attempt. But the FIDIC says even if no attempt has been made. So the translation was wrong. Don't use a translation for ruling between parties. Use it to understand the contract if you wish, preferably not. But don't consider it to be the 4th edition of the FIDIC. The 4th edition is this one. The translation is the translation of 4th. It's another contract. It's another contract. Can you imagine if I agreed with him, you know, that we have no jurisdiction, and these guys had to go through the process again, in his decision, amicable settlement, 4 months, 5 months, a new arbitration, forming a new arbitration tribunal, paying fees again, starting again in 6, 7 months, 1 year, if I agreed with him, for lack of knowledge or for lack of morals. Very nice case.
No, I remember it since I attended the CLAC 40 in 2010. I remember you, and the issue of translation.
And it's not my opinion, by the way. It's a blunt, expressly provided for provision, but that's not ambiguous at all. Even if no attempt. The same clause, you'll find it in subclause 20 regarding the dispute board decision, of course, not the EG's decision.
I will give the floor to Mr. Abdurrahman Mahdi, and then again to Engineer Askar. Abdurrahman.
So, good evening. So I had just a
لا لا خليها بس علي صوتك.
I had just a minor comment, is that the word and the user of word dispute avoidance instead of dispute resolution is actually very critical, as it solves many questions that can came in our minds. In fact, we might fear the impartiality or the independence of the partiality actually of or the dependence of the members of dispute board or any other issue. However, the rule is to avoid the dispute, not to solve the dispute, not to give the solution to the dispute. They try to avoid it. So even if, yes, they are required to be impartial or independent, but it's not so dangerous as much as it is in arbitration, for example, for them not to be impartial or independent. They should be, but if they are not, the danger is not like very critical, in my point of view, I think. And the same applies maybe to a lot of questions. For example, if we feel that I don't have enough time to submit my reply, for example, or any of these procedural issues that might arise during the procedure of dispute board decision or recommendation, constitution. So I just have the opportunity to submit a notice of dissatisfaction. So I have a solution that might give this decision or recommendation just a block or paralyze of application. So it's possible for me to stop any suits about impartiality or independence issues. So what would you think about that?
What's the question? I don't understand the question. I mean, a notice of dissatisfaction should not be abused. But even if it's issued, the decision is still binding. And if you don't comply, you are in breach, sometimes serious breach. So
Even if I issue a notice of dissatisfaction?
yes, the decision is binding but not final, according to the
Okay.
FIDIC. According to most of the standard forms of contract now.
Until the decision of arbitrator is issued.
Wait a minute,
So-
it's binding but not final. Or
Okay.
binding and final, depending on the situation. In both cases, it's binding upon the person who lost the case. So if he doesn't comply, he's in breach. And if you force the other party to do arbitration, you'll show that you're not acting in good faith because you did not fulfill or comply with a binding decision. You have no excuse, especially if the board upholds the decision, like we have seen in many cases. So what will your excuse be by not complying with the binding decision? What would you say in your statement of case? Because I didn't like it, but it's still binding. It's not accurate, it's still binding. Says who that the decision of the arbitrator will be more accurate than the dispute board member? Says who? Redford Hunter mentioned something about having specialized people in certain industries, construction, insurance, in the book. And he refers to a judge who says who that these guys would give a decision better than this court. That the court will give a decision that's better than their opinion.
Actually, it's what I'm saying, it's not whether it's better or more adequate or not, but it's more binding.
It is binding.
Yes, but
we just read it in the clause. It is binding, but not final. It becomes final if the parties are silent for a certain period of time, which is 28 days in the FIDIC. If they don't raise an issue of dissatisfaction, like Dr. Ismail said, then it becomes binding and final. So it's born binding, but can, after 29 days, become final as well.
Okay, and an arbitration decision is enforceable, for example, by force?
Arbitration award is enforceable by the court if the party that lost did not comply. Why should you force a person who won the case to go to court? That's not acting in good faith again. You're prolonging the resolution of dispute. You're delaying the payment to contractor during the lifetime of the project and after losing the case. And that's why I said we need lessons in morals. أخلاق.
Okay, thank you.
Engineer Oscar.
Let's assume there's a contract between two parties. There's a contract between
Two parties. The arbitration clause states that the arbitration will be conducted here in Kersika. And then the aggrieved party referred the matter to arbitration in reality, but the other party does not respond. Is it, what will be the way forward? The aggrieved party can proceed with arbitration in the absence of the other party?
Yes.
Is it possible?
Yes.
Yes, of course. The arbitration will continue as an ex parte arbitration. So there will be only a claimant. And the arbitration can proceed without the respondent, provided that the respondent is duly notified with every procedure. So we as Kersika, the Secretariat, will ensure that the respondent is duly notified in order to ensure that the arbitral award will not be subject to being annulled or set aside in the future. You're welcome. Yes, you have the floor, and please introduce yourself.
Working as Assistant General Manager for gas projects. I would like to thank Dr. Sherif for a great lecture, but I'm facing an issue during contract
I'm
formation.
always afraid of the word but.
Okay.
What comes after but cancels what comes before but.
Just I'd like to ask one question. During the contract formulation, I'm facing an issue with the top management in making and putting a mechanism for that, asking for the cost, that the cost will be more than higher if it shall be compared with ad hoc board.
So they always asking me to be preferred to avoid that according to the cost will be more expensive if compared if it shall be compared with the ad hoc according to the case by case. The second point is related to the appendix to the tender. Honestly, I'm facing a lot of issues regarding this matter. No parties nominated or appointed any kind of DAB. So what shall be the case regarding this matter? Shall I seek to nominate for a Corsica or asking for a certain adjudicator and send a notice for the contractor and waiting his answer, or what shall be done if it was not mentioned in the appendix to the tender?
Regarding cost, by the way, this is not correct in most of the cases. And you don't, if the solution is to use ad hoc adjudication as the case arises. But then, of course, you can select the adjudicator. You'll be one adjudicator or three. So the process will take 2-3 months to select an adjudication, during which time maybe another dispute or a third dispute has arisen. Will there be 7, 8, 9 dispute boards, whether it's sole member or 3 members? It's complicated, but it's possible. But of course, better than referring the matters to arbitration after 3-4 years, when lots of details are lost, lots of evidence is not available. Lots of people who work in the project have left the company, have died, have etc., and they cannot be called as witnesses. Sometimes left because of problems with the company. So there is no doubt in my mind that cases resolved with a standalone dispute board were accepted, as we have seen. I know of one case, whether in literature or in my own experience, since 2001, one case, there was a notice of dissatisfaction referred to arbitration, and the decision was reversed by arbitration. One case in the last 20 years. So cost is not always, consider the cost of arbitration. If you have a big case in arbitration, ICC cost will be much higher than Cairo Regional Center cost. Dubai is 3 times Cairo Regional Center. I just calculated, one person was telling me it's so expensive. What's the dispute between the parties? It was an ad hoc in my own office. I told you about it. So we calculated, I said, it's $3 in Cairo Regional Center. It's $9 in Dubai. So says who the cost is higher. So you have to compare it. If it's ICC, much higher. Dubai, much higher. Here, it's very moderate and very reasonable. I accept it as an arbitrator. I don't want Yani to cause the parties harm by having more money. But says who the dispute board, if properly selected and resolved all the disputes, costs more money. Did he make a calculation, this guy of yours? I don't think he did a calculation.
No.
He just looks at what he pays now.
Just making as a cost comparison, it shall be higher than to be employing DAB members and paying the money.
I'd like to read the study that he made to come to a conclusion that the board is cost. If it's costlier, why do people use it in these parts of the world, especially for major projects, by the way? Major projects, I assure you that arbitration, international arbitration, will not give as good a decision regarding the claims for complications and all and concurrencies and all this, for lack of good presentation by the parties. Impossible to present it good compared to presenting one case. But compare international arbitration in a big project, major projects, $200-300 million, $500 million, compared to arbitration. You'll find the arbitration will issue a decision in 2, 3, 4, 5 years, but with the project with adjudication, by the time for completion or the certificate is issued, there's no disputes at all. Like we have seen in, I've shown, by the way, 12 cases out of hundreds. So I don't know where we get our experience from in this part of the world. We just assume things, dream things.
Just I'm sharing with you what I'm saying from the top management.
That second question should be answered by Dr. Ismail, not by myself.
Yeah, just there's a case that we are facing really in contractual industry and the construction industry regarding the contractual drafting that try to be avoided. This is
try to avoid the DAP and create more disputes and avoid proper cash flow of the project, but insist the contractor completes on time with the same quality that he agreed to do. So is this what kind of contract is that? Try to avoid the DAP. The DAP are the devils of the world now. This is a very strange conclusion. I haven't even heard before. But the longer you live in this part of the world, the more you hear strange things. Avoid the DAP because of cost. That's the only element he's looking at.
As a
That's by the way, it's proven that cost is more than arbitration. International arbitration will cost more than the DAB statistically, by the way. If you search in Google,
the fees, yeah.
you'll find lots of comparisons there.
Okay, thank you.
Thank you very much, dear Professor Sherif El-Haggan, for this very, very interesting session, as usual and as expected. And promise me that this will not be the last time. You will always be welcomed at Corsica to deliver other lectures, not only on that, but on the construction industry in general. And I also thank the distinguished attendees, whether those who attended physically and are the most welcome to our premises, or those who attended virtually, who registered on Zoom, and also those who are following us live on Facebook. So I believe that this lecture was highly followed by people from different parts of the world. And apologies for the questions that remained unanswered. Unfortunately, we have to stick to the time. It's 2 hours. So I will be obliged to close this session. And I'm receiving a lot of thank you from the audience remotely. And I ask those who are physically attending with us to applaud to Professor Sherif for his great lecture. Thank you very much. I also want to thank my colleagues, Ms. Heba Rojdi, Engineer Yahya, and Engineer Sherif, and all other Corsica team who has supported us in order to make this lecture happen. And I also invite you to have some coffee break with us and to personally speak to Professor Sherif. Thank you.
شكرا شباب.